Hello, everybody. I'm Matt Pearson. I'm an attorney. One of the areas I practice in is criminal defense. Today we are live talking about criminal defense. I'm responding to some questions that I've received from people that have signed up for this. So we'll just get started. One of the questions I've gotten a lot actually, involves protection orders. The question is, somebody's asking if I'm the restrained party on a protection order, can I have an attorney contact the protected party? And the answer is yes. So an attorney can reach out, represent the restrained party in a protection order, whether it's civil or if it's a protection order coming out of a criminal case, for purposes of investigation, to see the protected party's position, to ask if they're willing to modify the protection order. That's all fine. That's all an exception to those protections. It wouldn't be considered you having a third party reaching out, which would violate the protection order. Your attorney can't contact someone and say, my client really misses you. They want me to tell you this, that, and the other. That would probably be a violation of the protection order. But as far as reaching out to see their position on the matter, to see if they want to drop it, proceed with it, have it modified, and then also ask them what happened in the other underlying events, that's all perfectly legal. In fact, there's no way those cases could get handled without an attorney being able to speak to that person, unless they had their own attorney representing them. I had a question come up today. Somebody who said, I have a case in a specific county from 2012. Never appeared on it. Has the statute of limitations run? The answer is no. What the statute of limitations is it both in civil and criminal, is there's a specific amount of time in which either a civil action, or since we're talking criminal today, in which charges can be brought. But once the charges have been brought, once there's been a warrant issued and a case open, even if someone hasn't been arrested and served with that warrant, there's still a case open. The charges have been filed. Once charges are filed, statute of limitations is not an issue anymore. As long as those charges were filed within the statute of limitations, the idea being that someone can't just hide for 10 years or whatever and come back and say, well, I know I had a case filed, or I'm aware now that there was a case filed, but it's been past the statute of limitations. It just doesn't work that way. That's not how the statute of limitations works. Interesting question. And I think I talked about this last week, for those of you that were lucky enough to hear me talking about DUI checkpoints last week. And the question is there ever a time when a DUI checkpoint is not legal? I think I'm going to answer this backwards and tell you what makes a DUI checkpoint legal. And if people are asking what's a DUI checkpoint, law enforcement can set up a situation where people drive through this DUI checkpoint, and you roll your windows down and they ask you a few questions. And if they notice some signs of impairment, odor of alcohol, something else, then they can start a DUI investigation without having to have a reason to have pulled you over in the first place or contact you in the first place. So Fourth Amendment provides protection against unreasonable intrusion from the government, which means they can't just arbitrarily pull people over. They have to come up with some sort of a pretext or reason for stopping you, typically. I observed the car speeding. I noticed the car couldn't maintain a lane. They didn't signal to change lanes. Some sort of a traffic infraction usually. But a DUI checkpoint gets rid of that component. And the reason is that it's set up so that basically it's voluntary. So here's what makes a DUI checkpoint legal. There's certain things they have to do as far as publication. Some back page of a newspaper, they have to put notice that they will be running a checkpoint at a certain date and time, and at least describe the general area. You're probably not going to see that, but it is a box that has to be checked. The big thing for you, the driver, somebody driving a car, is a DUI checkpoint has to be marked. There has to be signage before you drive into the checkpoint. And for it to be legal under the Constitution, So it's not considered a Fourth Amendment search, but rather considered you voluntarily went into the checkpoint. When you see that signage, there has to be a way around the checkpoint after the sign. So you'll see one of those, say, electronic road signs saying DUI checkpoint ahead. When you drive past it, there's a checkpoint in front of you. There has to be either a way to make a left turn or a right turn, or to turn around and not go into the checkpoint. If you don't drive into the checkpoint, it's not legal for the police to just pull you over solely based on they saw a car that decided not to go into the checkpoint. They can follow you if they're handling it that way and look for another reason to stop you. But that typically doesn't happen. So that's really what makes a checkpoint legal. There's a bunch of other factors. It has to be a reasonable amount of time for the stop. So if there's no reason for them to investigate any further, there's no odor of alcohol, it really is supposed to be a brief, hey, how you doing? We're doing a DUI checkpoint. Have you been drinking tonight? You're sent on your way. But the real key piece here is there has to be signage indicating that there's a checkpoint ahead, and there has to be a way for a motorist to avoid that checkpoint. So the signage has to come before you're stuck driving straight into the checkpoint. Another question, is self-defense hard to prove in a domestic violence situation? It depends. The self-defense is an affirmative defense to some sort of an assault or harassment charge, typically, or in more serious situations, homicide. And self-defense, the elements of it are basically that someone had to protect themselves, that they were threatened to the point where a reasonable person would feel like they were in danger. That would apply the same to a domestic violence situation as it would to any other situation. I think there's factors that depend on how easy it is to prove. For example, if the party claiming self-defense is a 240-pound bodybuilder, and the other party, the person who is the alleged victim in the case, is about 110 pounds, it's going to be tricky maybe to get a jury to buy that, or get a DA sold on it. Now, if there's weapons involved and things like that, self-defense can be a defense to a domestic violence situation. As far as how easy it is to prove, probably not super easy and really fact dependent. We'd have to have something more specific as far as a hypothetical. You'd certainly need an attorney to analyze that case to see if there's a legit self-defense claim. Another question, and this is a good one, if the car you're riding in is pulled over, so you're not the driver, you're a passenger, what are your legal rights as a passenger? Do you have to give your ID to the police officer? And in my opinion, the answer is no. No, you don't. And I see a lot of law enforcement that ask people for IDs all the time. Even if somebody's assisting them and in like there's a fight that breaks out at a party, they just ask everybody for their ID, and then they'll run it just to see if there's any warrants out. That's what they're looking for a lot of the time. If you're just the passenger in a car, you can just say, no, I'm not giving you my ID. They'd have to find another reason to demand that identification. They being the police, of course, would have to come up with some sort of a reasonable suspicion, some sort of something they can sell the judge on later that they thought you might be involved in some sort of criminal activity. So if you're driving in a car, for example, and your friend's pulled over on suspicion of a DUI and they start asking you for your ID, you just say no. And that's perfectly legal. They don't have any basis really to try to figure out who you are or what you're doing. Another question here is, how could a lawyer benefit me if I plan to plead guilty anyway to assault charges? So I think the question is somebody's saying, I've already made up my mind. I'm charged with assault. I'm going to plead guilty. I think there's two answers to that question. Is one, before you enter that plea, you should still consult with an attorney if you haven't, to see if there's a good argument for a reduction in the charge to something lesser than an assault, like a harassment charge. If based on someone's criminal history, the prosecutor might be willing to do some sort of a plead guilty but avoid a conviction type of situation, what we call a deferred judgment, to do a case analysis to make sure you should be pleading guilty to these charges, and to make sure that it's not impossible to convince the prosecution to make a better offer than plead guilty to assault. even if it's still going to be a matter of, yeah, you're pleading guilty to assault, an attorney is really helpful to advocate for you at sentencing. It's hard for an individual to sell the court on who they are, why this isn't them. And I mean, these charges aren't indicative of who this person is, what kind of work they've done, why the court can trust that they're not a public safety risk. Having an attorney selling that to the judge and the DA can be very helpful in making sure that the sentence is as minimal as possible, that you're exposed to less jail time, that you're exposed to a shorter term of probation potentially. And attorneys are very useful to help walk you through what should you do before you go to sentencing to help sell the judge on being lenient. What kind of things does the court want to hear so that the court can be lenient? So I would suggest, I think a lawyer can benefit you in pretty much very many situations, including if you're going to plead guilty, you still want help with mitigation of the possible penalties for what you're pleading guilty to. If you're arrested but never charged with a crime, do you still have a record? Possibly. I mean, not always, but sometimes, yes. I've had people where they were arrested and there was a decision made not to charge the crime. So it never even got to court. There was never a court case open, but that arrest still shows up on a background check. And yeah, that can be sealed. The problem is there's no, under the new Colorado, and by new, I mean about 3 years old now, Colorado procedure for sealing cases, criminal cases, it was simplified in that you used to have to file a civil case to try to get a civil court to order the criminal court to seal the case. They simplified that, the state legislature, so that you just file directly into that criminal case now. It's much simpler. Instead of having one court tell another court, you need to seal this, you get an order right from that original court. And then we get that order to all the law enforcement agencies that have custody of the records so that they're sealed. It doesn't get reported on it, your standard background check. In this scenario, arrested, not charged, there's no criminal case for us to file the motion into. We have to use the old process of filing into district court under the old civil process, asking for that district court to give us an order to send to that arresting agency, telling them that that arrest has been sealed. So it can be done, just a little bit, not quite as simple. Can a police officer, another question here, it's a good one. Can a police officer demand to know about your immigration status? No, not in my opinion. I don't know. And I think there is precedent on the side of that, but I haven't dug in and done all the legal research on it. Just in my experience in practicing, courts, so this also applies in court, judges will not ask you your immigration status. And I believe that law enforcement is not supposed to. Sometimes they do things that they're not supposed to do. So they might ask you, but they shouldn't be. And the basis for that is the Constitution, the wording of the Constitution protects people. So whether you're a citizen or not, you're entitled to the constitutional protections of the United States as a human being here. So the immigration status isn't relevant. It could be considered prejudicial if they're asking you that. So law enforcement, the courts, in my experience, don't ask that question. Next question is a DUI question. Should you ever answer a cop if he asks you if you've been drinking and how many drinks you have had? Well, if you haven't had anything to drink, then yeah, you can say, I haven't had anything to drink, officer. If you have, it's tricky because if you say no, I haven't had anything to drink, that officer is put in his report, well, he said he or she said they had nothing to drink. And I noticed the odor of alcohol coming from the car. And later when that individual blew into a portable device or consented to some sort of a test, it came back that there was alcohol in their system. And now you have a credibility problem. You've already been dishonest. And if we go to trial, you've already got a DA saying, well, this defendant lied before. So you have to be careful with it. It's a very tricky situation because If you say, yeah, I had a beer, then you're kind of walking into that. Well, everyone says they had 1 or 2 beers. So maybe the best approach would be, depending on the facts. And again, this isn't legal advice, because it depends on what's going on. And unfortunately, you can't have an attorney. Well, maybe some people can have an attorney riding shotgun in their car to give them advice in that situation. But typically, you don't have your lawyer with you. And law enforcement doesn't have to let you call your attorney while they're investigating you. If you say, I want a lawyer, it's not that they hand you a phone and let you call your lawyer. They just stop asking you questions. And even further, under Colorado Express Consent Law, which is what directs drivers in the state of Colorado to the requirement of providing a blood or breath sample of their alcohol or drug content in their body, it specifically says you don't get to consult with a lawyer before making your decision on whether you take the test and which test you take. So one way to handle it would, if you're being asked, have you had anything to drink tonight, is just to respond, I'm not even sure why you're asking me that and why you pulled me over. And they'll probably say, well, you were speeding. And you say, well, I don't understand why you pulled me over, and just kind of don't answer. If you say you had 3-4 beers, they're going to continue. Even if you say you have 1 or 2 drinks, that will let law enforcement continue their investigation. You may want to consider not giving additional evidence by way of admission of having consumed alcohol. And of course, the best way to avoid it is not to drink and drive, but I think that's obvious. So I'm not sitting here trying to tell you how to get around it. But if you end up in that situation, you probably want to avoid answering that question. And of course, if you haven't had anything to drink, you might as well say no. And a good follow-up question here: if you are arrested for a DUI, can you choose between a blood or breath test? And the second part of that is, if so, is one better than the other? That's a trickier question. We'll put that aside for now. Can you choose between a blood or breath test? Answer is yes. And express consent law is unclear on exactly what the officer has to say to you as far as the advisement. So the law says a driver in the state of Colorado, if an officer has probable cause that their driving is affected by alcohol and or drugs, that individual has already consented to providing a blood or breath sample. You can choose, okay? If it's drugs involved, however, if the officer believes drugs are involved, then they can say, sorry, you can only take a blood test. I'm only offering a blood test, because the breath test doesn't have any way to measure whether any sort of substance is present in somebody's system except for alcohol. So if it's a situation where the officer is seeing signs of marijuana use, you would only be able to choose the blood test, okay? There's other situations where you can choose a blood test if there's something going on that law enforcement can't control. There's no phlebotomist because of some sort of weather condition. There's some act of God going on where one of the tests is impossible. I had a case once where the breath test machine, it was City of Glenwood Springs. Both of them were broken. Okay, so the officer said you can only take a blood test. Now, that worked out in our favor because the intoxilizer machine, the breath machine, 10 minutes down the road in Carbondale was working just fine. But, that was fact dependent. But typically speaking, you get to choose between a blood or breath test unless there's an allegation of drugs being involved. Then you only get a blood test. You can refuse as well, but there is a consequence for refusing through the DMV, as far as the revocation being 2 years. And also the prosecution, if you take your case to trial, can basically argue that you refuse to take that test because you knew the results were going to be bad. There's a defense argument to counteract that, saying you're just assuming, the prosecution's just wanting you being the jury, to assume that this test works. And we don't know that the test works. We don't know how the test works. The driver didn't trust the results of this would be accurate and that they might be providing evidence of guilt when they're really not guilty. So that's kind of how that's handled, but they can use the refusal against you. If so, is one better than the other? I don't know. I've heard people say the blood tests are more accurate. The nice thing about a blood test is that there's an independent second sample held that the defense can send to a different lab to have them run the blood test and see if there's a big difference between the two results. There's no sample saved in the Intoxilyzer 9000 breath machine. It does take two measurements. And there's also some fun that defense attorneys can have with the Intoxilyzer 9000 if it goes to trial, which is basically nobody knows how that machine works and why we're supposed to know it's accurate. Law enforcement can explain how they operate the machine. But if you ask them, okay, but how do we know the machine works properly? They really don't know the answer to that. The diagnostics, the information on that machine are not public. The company that manufactures it has, my understanding is they're saying it's a trade secret. It's our work. It's our invention. We're not going to disclose how it works because it's protected under federal law. It's a trade secret. So basically, the way we're supposed to just believe that the Intoxilyzer 9000 works is because the state of Colorado tells us it does. And the way we're supposed to believe that it's working properly is because if it's not working properly, the machine tells you that it's not. So, you can see there's a little bit of fun to be had from a defense perspective with the Intoxilyzer. With the blood, it's more a matter of getting into the literature that the phlebotomists will be relying on when they're testifying at trial to form their opinion, and just trying to convince a jury, look, that this blood result, there's nothing here that definitively says it's connected to impairment, particularly in a case where you don't have a sign of impaired driving. That could be a decent defense. Particularly with the marijuana and the drug cases, there's much more research that connects certain levels of alcohol in your system to a greater likelihood of being involved in accidents and things like that. And there's not as much of that scientific literature when marijuana or other drugs are involved. So I don't know if one's better than the other. It's long story short, there's some benefits on both sides. Last question that I have for this week is, does everyone convicted of a DUI in Colorado get an interlock device on their car? Can you get one of these instead of having your license suspended? So the interlock is a restricted license. So if you have an interlock installed in your car, what you've done is you've gotten a restricted license that only allows you to drive a car with the interlock in it. So that basically, that is, instead, it's not suspension. It's the same thing, though. It's revocation. You've had your license revoked for a DUI, and there's two ways you can get revoked by the DMV. One is for having a blood alcohol content over a 0.08, and that triggers the revocation. And depending on how many priors there are, it's either 30 or 60 days, and then you're allowed to get that restricted license with the interlock in the car. And also, depending on how many priors there are, it could be for 4 months, 9 months, 2 years. It kind of depends on if there's been a prior offense or not. And also, if the BAC is over a 0.15, so 0.08, which is basically 8% blood alcohol content at the time of the test. 0.15 is more. If you're over that 0.15, the amount of time with the interlock in your car is longer. Everyone convicted of a DUI in Colorado get an interlock, but you don't have to get the interlock. Although in some situations you can just do the year suspension, get your driver's license back. If you want your license early so you can be legal to drive, interlock's an option. In some cases, like a refusal, or if you fall into other categories that the DMV considers what's called persistent drunk driving, which Even if you have never been arrested for a DUI before, if you refuse to take a chemical test, you fall into that category. Or if you have priors, you're a persistent drunk driver. Or if there's a BAC over that 0.15 I talked about, even with no priors, you fall into that persistent drunk driver category with the Department of Motor Vehicles. We're not talking about the criminal courts, talking about the DMV. Then you probably will have to have that interlock in your car at some point. There's really not a reason not to, because it's better to be legal to drive than not. And that interlock is a nice option. It didn't always exist under Colorado law. So it's a great way to get people legal to drive again, so you can go to work and do all those things. So you can have an interlock. There's one scenario, and unless the rules with the DMV have changed recently, is if you're convicted of a DWAI, not a DUI, the lesser offense of driving while ability impaired, and you didn't have a blood alcohol content over a 0.08, so you escaped a revocation through the DMV, or somehow you won your DMV hearing, the officer failed to appear. I was able to convince the hearing officer that there was no basis for the stop, or that the test wasn't done within 2 hours. You'd avoid that initial revocation. The DMV gets another shot to revoke you based on the criminal conviction. A criminal conviction for a DUI on a first offense will revoke you. A criminal conviction for anything, DWAI, DUI, if there's a prior, so second, third, fourth offense, will revoke you. But with no prior, if you plead to a DWAI and you haven't been revoked per se for the over 0.08, my experience has been that you avoid that revocation because the DWAI is an 8-point traffic offense, doesn't trigger the automatic revocation, and doesn't trigger the 12-point suspension. Now, if that's changed, I'm not aware of it. It's been like that for as long as I've been practicing DUIs, where we'd have a client in that scenario, first offense DWAI, and they hadn't been revoked for the original per se revocation with the DMV. They did avoid that driver's license consequence. Anyway, everyone, it's Friday. Be safe out there. Have a great weekend. We'll see you here next week. Love the questions. Keep them coming.